now therefore look at the relevant provisions bearing on the issues in contention as a whole in order to give effect to the objectives of the Constitution. Whether this court can depart from its previous decisions. The issues and arguments raised by the parties have invariably compelled us to consider the question whether this court can depart from its previous decisions. It was submitted by the petitioner that there are instances in which the court may forget or omit a statutory provision or point of law when rendering judgment. That in such circumstances the court has the power to correct these errors through the principle of per incuriam. The third respondent supported the petitioner's position on this issue and further submitted that the doctrine of per incuriam is an exception to the legal principle of stare decisis. It was also submitted that this court, being the apex court in constitutional matters, has jurisdiction to review and overrule its previous decisions. The first respondent, on the other hand, submitted that this court has stated its position on his eligibility to contest the presidency on 3 occasions. It was further argued that the mode of reopening the matter for the court to review its decision was wrong, and that the court therefore has no jurisdiction to entertain this petition. The second respondent did not make any submissions on this issue. To address the issue, we begin with the doctrine of precedent, often expressed by the Latin maxim stare decisis et non quota mover, that is, to stand by decisions and not disturb settled matters, which requires that a legal principle that has been established by a superior court must be followed in other similar cases by that court and other courts. It should be noted that a court departing from its previous decision is a different legal concept from a court reviewing its own decision. The former refers to a court taking a different position in another different matter, while the latter refers to a court reviewing its position in the same matter. In the case at hand, the court is being asked to depart from its previous decisions. In order for us to adequately address the issue of whether this court can depart from its previous decisions, it is helpful to do a comparative analysis with other jurisdictions and also consider the position in Zambia before 2016 amendments to the Constitution. Apex courts in Africa, the Commonwealth and beyond have had to confront the issue regarding their jurisdiction on departing from previous decisions. Persuasive insights are deducible from various court decisions from other jurisdictions as well as ours regarding this question. We therefore now proceed to recite some of these decisions in an endeavor to determine the position of this court on the issue. Number 1, the South African position. The South African Constitution provides under Section 173 that the Constitutional Court, Supreme Court, Court of Appeal, and High Courts have the inherent power to protect and regulate their own process and to develop the common law, taking into account the interests of justice. In the case of Counts Bay Ratepayers and Residents Association and PS Booksellers Private Limited versus Gerda, Yvonne Eda Harrison, and Municipality of the City of Cape Town, the Constitutional Court stated that this argument raises issues concerning the principle that finds application in the Latin maxim of stare decisis, in brackets, to stand by decisions previously taken, or the doctrine of precedent. Considerations underlying the doctrine were formulated extensively by Harlow and Kahn. What it boils down to, according to the authors, is certainty, predictability, reliability, equality, uniformity, convenience. These are the principal advantages to be gained by a legal system from the principle of stare decisis. Observance of the doctrine has been insisted upon both by this court and the Supreme Court of Appeal, and I believe rightly so. The doctrine of precedent not only binds lower courts but also binds courts of final jurisdiction to their own decisions. These courts can depart from a previous decision of their own only when satisfied that the decision is clearly wrong. Further, and in the case of Lina Jackson Nyaba versus Minister for Safety and Security and 4 others, the Constitutional Court of South Africa stated as follows. The doctrine imposes a general obligation on a court to follow legal rulings in previous decisions. Masaneke J acknowledged the recognized exceptions to the stare decisis, namely where the court is satisfied that its previous decision was wrong, or where the point was not argued, or where the issue is in some legitimate manner distinguishable. A higher court of appeal, and this court in particular, has to be especially cautious as far as adherence to or deviation from its previous decisions is concerned. It is the upper guardian of the letter, spirit, and values of the Constitution. This court must not easily and without coherent and compelling reason deviate from its own previous decisions or be seen to have done so. One exceptional instance where this principle may be invoked is when this court's earlier decisions have given rise to controversy or uncertainty. 2. The Nigerian position. In Nigeria, there is no constitutional provision which expressly vests the Supreme Court with powers to review and depart from its own decisions. Article 235 of the Constitution of the Federal Republic of Nigeria provides that, without prejudice to the powers of the President or the Governor of a state, with respect to prerogative of mercy, no appeal shall lie to any other body or person from any determination of the Supreme Court. However, and notwithstanding the express prohibition in the case of Amalgamated Trustees Limited versus Associated Discount House Limited, the court made the following pronouncement. The Supreme Court, as is the practice in other superior courts of record, possesses inherent power to set aside its judgment in appropriate cases. Such cases are as follows. 1. When a judgment is obtained by fraud or deceit. 2. When the judgment is a nullity, such as when the court itself was not competent. 3. When the court was misled into giving judgment under a mistaken belief that the parties had consented to it. 4. When judgment was given in the absence of jurisdiction or where the procedure adopted was such as to deprive the decision or judgment of the character of a legitimate adjudication. 3. The Kenyan position. Article 163, Subarticle 7 of the Kenyan Constitution provides that all courts other than the Supreme Court are bound by decisions of the Supreme Court. In the case of Frederick Otieno Outa versus Jared Odoyo Okello and 3 others, the Supreme Court in its ruling had this to say concerning the said provision. It is clear to us that Article 163, Subarticle 7 of the Constitution can only be invoked by a litigant who is seeking to convince this court to depart from its previous decision on grounds, for example, that such decision was made per incuriam, or that the decision is no longer good law, and so on. This provision cannot be invoked by a losing party as a basis for the court to review its own judgment, decision, or order. Nor can it confer upon the Supreme Court jurisdiction to sit on appeal over its own judgment. In our view, reviewing a judgment or decision is not the same as departing from a previous decision by a court. That court in this matter held as a general rule that it has no jurisdiction to sit on appeal over its own decisions, nor to review its decisions. That, however, in exercise of its inherent powers, the court may, upon application by a party or on its own motion, review any of its judgments, rulings, or orders in exceptional circumstances, so as to meet the ends of justice. 4. The Zimbabwean position. The Constitution of Zimbabwe is silent on the Constitutional Court's power to review its own decisions. However, Section 5(4) of the Constitutional Court Act clearly provides that the Constitutional Court is not bound by its own decisions. It is noteworthy, however, that even before the Zimbabwean Constitutional Court Act was enacted, the Constitutional Court of Zimbabwe had taken a position on the power to review its own decisions as well as the power to depart from its own decisions. In the case of President of the Senate and 2 others versus Innocent Gonese and 3 others, the court stated thus: whilst the Constitutional Court Act is yet to be promulgated, the absence of the equivalent of Section 26 of the Supreme Court Act for the Constitutional Court is of no impact. The words of the Chief Justice in Litton Investments case on the finality of decisions of the Supreme Court on non-constitutional matters apply with equal force to the finality of the decisions of this court on all constitutional matters. A decision of the Constitutional Court on a constitutional matter is final. No court has power to alter the decision of the court. Only this court can depart from its previous decisions, rulings, or opinions. I venture to add, for emphasis, that only this court, in a future and appropriate constitutional matter, may overrule or depart from its previous order. 5. The United States of America, USA position. In a landmark decision of the USA Supreme Court in Dobbs, State Health Officer of the Mississippi Department of Health, etc., versus Jackson Women's Health Organization, etc., in which the court overruled its earlier decisions in both Roe versus Wade, 1973, and Planned Parenthood versus Casey, 1972, the court stated that we have long recognized, however, that stare decisis is not an inexorable command, and it is at its weakest when we interpret the Constitution. It has been said that it is sometimes more important that an issue be settled than that it be settled right. But when it comes to interpretation of the Constitution, the greatest charter of our liberties, we place a high value on having the matter settled right. The USA Supreme Court further went on to state that when one of our constitutional decisions goes astray, the country is usually stuck with a bad decision unless we correct our own mistake. An erroneous constitutional decision can be fixed by amending the Constitution, but our Constitution is notoriously hard to amend. Therefore, in appropriate circumstances, we must be willing to reconsider and, if necessary, overrule constitutional decisions. 6. The Zambian position. Article 125, Subarticle 3 of the Constitution provides that the Supreme Court is bound by its decisions except in the interest of justice and development of jurisprudence. There is no similar provision with regard to the Constitutional Court. Prior to the 2016 amendments, the Supreme Court was the only apex court in Zambia and had final jurisdiction over all constitutional and non-constitutional disputes in the country. The provisions of the Constitution then were silent on the Supreme Court's power to review or depart from its previous decisions. However, in exercise of its inherent jurisdiction as an apex court, the Supreme Court reviewed and departed from its earlier decisions in exceptional circumstances. Thus, in the case of Davis Jockey Kasote versus the people, the Supreme Court stated as follows: the Supreme Court, being the final court in Zambia, adopts the practice of the House of Lords in England concerning previous decisions of its own, and will decide first whether in its view the previous case was wrongly decided, and secondly, if so, whether there is sufficiently strong reason to decline to follow it. Further, and in the case of Finsbury Investments Limited and three others versus Antonio Ventriglia and another, the Supreme Court stated as follows: clearly, as the foregoing authorities establish, this court has unfettered inherent jurisdiction, and in appropriate cases, it can reopen its final decisions. This court will not, however, reopen its decision mere on the ground that a party to that decision is dissatisfied with it and wants a more favorable decision. In our considered view, the power of this court to reopen its decision can only be invoked in exceptional circumstances where the interest of justice demands that to be done. Considering the above authorities, it is clear that apex courts in common law and other jurisdictions enjoy unfettered inherent power to review or depart from their previous decisions in exceptional circumstances. The courts have, however, been careful to state that they will only review or depart from their previous decisions in exceptional and compelling circumstances so as to meet the ends of justice, such as where the previous decision was clearly wrong. This is a delicate balance for the courts between the need for finality in litigation and the overriding duty of the court to dispense justice, and to dispense justice where circumstances so demand. There is no legal provision which divests this court of its inherent jurisdiction to depart from a previous decision in exceptional circumstances. It is thus our position that whereas this court, as the guardian of the letter, spirit, and values of the Constitution, has to be circumspect as far as adherence to or deviation from its previous decisions is concerned, it shall not hesitate to depart from previous decision where it is satisfied that the decision is clearly wrong or where the interest of justice demands that to be done. In our considered view, departure from precedent must, however, only be taken in the most exceptional circumstances. We therefore find the argument that this court has no power to review or depart from its previous decisions fundamentally flawed. It in effect would entail the court divesting itself of powers that flow from its standing as an apex court. Whether the petition is res judicata. We note the arguments and cases cited by the parties on res judicata, and they all agree on the principles that govern res judicata, and we agree with them. It was submitted by the first respondent that the petition brought before this court is res judicata, this court having previously pronounced itself 3 times on the same matter. The petitioner and the third respondent, however, argued that this matter is not res judicata, as this case is sui generis. It was submitted that the action has brought out a context that has never been determined by this court. That is the effect of sections 2 and 7 of the Act as read with the repealed Article 35 of the Constitution. Res judicata is defined on page 1504 of Black's Law Dictionary, 10th edition by Brian A. Gunnar, thus: Latin, a thing adjudicated. 1. Any issue that has been definitively settled by judicial decision. 2. An affirmative defense barring the same parties from litigating a second lawsuit on the same claim or any other claim arising from the same transaction or series of transactions, and that could have been but was not raised in the first suit. The three essential elements are: 1. An earlier decision on the issue. 2. A final judgment on the merits. And 3. The involvement of the same parties or parties in privity with the original parties. The doctrine of res judicata is, however, not an absolute principle, and there are several exceptions, including: 1. Lack of jurisdiction. 2. Presence of fraud or collusion. 3. Material changes in the law or facts. And 4. Mistake or per incurium. Comparative jurisprudence also shows that the doctrine is not absolute. In the English case of Fidelitas Shipping, Lord Denning, master of rolls as he then was, said, "The rule then is that once an issue has been raised and distinctly determined between the parties, then as a general rule, neither party can be allowed to fight that issue all over again. The same issue cannot be raised by either of them again in the same or subsequent proceedings, except in special circumstances." The Constitutional Court of South Africa, in the case of Molaudzi versus S, also affirmed the development away from the strict application of common law of res judicata, and stated as follows: "Since res judicata is a common law principle, it follows that this court may develop or relax the doctrine if the interests of justice so demand. Whether it is in the interest of justice to develop the common law or the procedural rules of the court must be determined on a case-by-case basis. Section 173 of the Constitution does not limit this power. It does, however, stipulate that the power must be exercised with due regard to the interest of justice. Courts should not impose inflexible requirements for the application of the section. Rigidity has no place in the operation of court procedures." The court further held that it could depart from the doctrine of res judicata where the case at hand demonstrated exceptional circumstances that cry out for flexibility on the part of the court. It is trite that where the doctrine of res judicata is sought to be relied upon as a defense, the purpose of the principle is to balance the public interest and finality of litigation with the public interest of ensuring a just result on the merits. In light of the foregoing authorities, we are of the firm view that the doctrine of res judicata is not an absolute principle. It is subject to exceptions which are relevant to the present petition, as shall be determined in due course, include circumstances where the previous decision was made per incurium. Whether the first respondent was eligible to contest the August 2021 presidential elections. In his submissions, the first respondent urged the court to uphold its previous decision in the Legal Resources Foundation case that he was eligible to contest the 2021 elections. It was further argued that this petition is incompetent, as in essence it seeks to challenge the nomination of the first respondent outside the time frame prescribed in Article 52 of the Constitution. On their part, the petitioner and the third respondent submitted that the court interprets the combined meaning of sections 2 and 7 of the Act, as well as the repealed Article 35 of the Constitution, and urged the court to find that the inclusion of the first respondent on the 2021 presidential ballot was unconstitutional. The second respondent did not submit on this issue. We have taken into account the varying positions taken by the parties on this issue. In the Legal Resources Foundation case, in which the first respondent's eligibility to contest the 12th August 2021 elections was challenged, we stated as follows on pages J77 and J78. We find that Article 1063 of the Constitution does not bar the first respondent from contesting the forthcoming presidential election scheduled for 12th August 2021. For that reason, we hold that the first respondent's nomination, which was accepted by the returning officer on 17th May 2021, is valid, and that the first respondent, Edgar Chagwalungu, is qualified and entitled to stand for election as president on 12th August 2021. At the time of the holding of the 2021 elections, our decision in the Legal Resources Foundation case was binding, thereby enabling the first respondent to stand for election as president on 12th August 2021. This we affirm against a backdrop of the well-settled principle that court decisions and orders are binding and must be obeyed unless set aside or expire due to a fraction of time. This is the view we took in the case of Bernard Kamingo versus the Attorney General and the Electoral Commission of Zambia. Therein, we held that we wish to state that the Court of Appeal does not have jurisdiction to hear appeals to cases whatsoever dealing with Article 52(4) of the Constitution. Nevertheless, that stay order it had issued had to be obeyed, even though erroneously issued, and remains in force until discharged or set aside. The declaratory reliefs 1, 2, and 3 sought by the petitioner, urging this court to declare that the Electoral Commission of Zambia's inclusion of Edgar Chagwalungu on the 2021 ballot and his participation in the August 2021 election unconstitutional are therefore hereby dismissed. Amicus curiae. We now wish to refer to the brief filed by the friend of court, Mr. Sangwa, State Counsel. A review of his filed brief reveals that the gist of Mr. Sangwa's submission is that there is no provision in the Constitution that vests authority in this court to interrogate eligibility of a losing presidential candidate to take part in the election, post-election, which he has lost. He further submitted that a decision of the court in favor of the petitioner in that respect will not only affect the first respondent, but all those who took part in the 2021 elections without the court hearing them. Further, that it would also question the legality of the 2021 presidential election that included an unqualified candidate. However, and in view of our finding that the first respondent was cleared to stand for election as president in accordance with the decision of this court, Mr. Sangwa's submissions and arguments are of no consequence. Whether the first respondent is eligible to participate in any future presidential elections. In his submissions, the petitioner submitted that the first respondent does not qualify to participate in any future elections under the Constitution. This, he argued, is due to the fact that he has served 2 full terms and will therefore be in violation of the Constitution if he attempted to seek a 3rd term. It was submitted that the first respondent participated and won a presidential election in 2015, which culminated into his first term under the repealed Article 35 of the Constitution. Further, that for the second term, he was elected under the Constitution as amended in 2016, and that this Constitution does not apply to his first term as it has no retrospective effect. The court was urged to depart from its decision in the Legal Resources Foundation case, as it had completely omitted to take into account the provisions of Section 2 of the Act and was therefore per incuriam. The first respondent, however, submitted that the majority decision in the Legal Resources Foundation case comprehensively dealt with his status, that the said decision upheld the decision in the Daniel Pule case, in which it was held that the first term cannot be considered as a full term for purposes of Article 106, sub-Article 3 of the Constitution, and that therefore Article 106 of the Constitution did not bar the first respondent from contesting the August 12, 2021 election, and by extension, future elections. It was also submitted by the first respondent that the Legal Resources case was not per incuriam, as the dissenting judgment made reference to Section 2 of the Act, which meant that the judges were aware of this provision. It was further argued that this petition was wrongly before this court, as it had come by way of an appropriate, as it had not come by way of an appropriate motion for review of the court's earlier decision. The court was called upon to uphold its earlier decision in the Legal Resources Foundation case. The first respondent is urging us to uphold our decision in that case, as the decision was correct and binding. In its submissions, the second respondent relied entirely on the answer, affidavit in support, and skeleton arguments filed on 16th November 2023. In his submissions, the third respondent submitted that the Legal Resources Foundation case did not pay particular attention to, nor did it take into consideration, Section 2 of the Act. It was further submitted that there was no need to provide for transitional provision in Section 7 of the Act, as the issue at hand was catered for in Section 2 by the definition of which constitutional provision applied on the effective date. Further, that the repealed Article 35 of the Constitution was clear in speaking to twice elected and not holding office. That the first respondent was therefore deemed to have twice held office and was barred from participating in any future elections. It was also submitted that ultimately, whether the issue has been pleaded or not, the court is being called upon to invoke the per incuriam rule. This court, in its majority decision in the Legal Resources Foundation case, asked itself a question as to whether framers of the Constitution in the transitional provisions under the 2016 constitutional amendments made provision for what was to happen to the incumbent president's term of office, which according to the court straddled two constitutional regimes. The court then looked at the provisions of Section 7.1 of the Act and came to the conclusion that the said provision shows that although the Act provided for the continuation of the President in the office of President, it made no provision for how the period served from January 2015 to September 2016 was to be treated in view of the change in the constitutional provisions from the limitation based on being twice elected to holding office for 2 terms. The court then proceeded to draw inferences on what the framers of the Constitution must have intended, and based on the provisions of Article 106 of the Constitution, concluded that Article 106, sub-Article 6 of the Constitution regarding the full term must be applied to defining what is meant by twice held office in Article 106.3 in interpreting the provisions of that article. Based on the above, the court then proceeded to conclude that the term served by the first respondent from 25th January 2015 to 13th September 2016 was an inherited term and not a full term as defined by Article 106, Subarticle 6 of the Constitution. Consequently, it was held that Article 106, Subarticle 3 of the Constitution did not bar the first respondent from contesting the 12th August 2021 elections. We have carefully considered the arguments by all parties in this petition. First, we wish to correct the misconceived view suggested by the first respondent that this matter is an application for review. To the contrary, our firm view is that the petition is beseeching us to depart from or overrule our previous decision in the Legal Resources Foundation case, as it was arrived at per incuriam. We note further that in that decision, there was no reference to Section 2 of the Act throughout the majority judgment, and a combined interpretation of Section 2 and 7 of the Act, read together with the repealed Article 35 of the Constitution, was never made. It is not in dispute that the first respondent was elected and sworn into office of President on 25th January 2015 under the repealed Article 35 of the Constitution. With regard to term limits, the repealed Article 35, 1 and 2 of the Constitution provided that Article 35, 1. Subject to clauses 2 and 4, every president shall hold office for a period of 5 years. Article 35, 2. Notwithstanding anything to the contrary contained in this Constitution or any other law, a person who has twice been elected as president shall not be eligible for re-election to that office. In 2016, the Constitution was again amended. The question therefore is, with the coming into effect of the 2016 amendments, what happened to the office of the president since his term was continuing up to September 2016? The answer to this question lies in the preamble to the Act, which states, "In Act to provide for the printing and publication of the Constitution, to provide for the savings and transitional provisions of existing state organs, state institutions, administrations, offices, institutions, and laws." From the wording of the above provision, it is clear that framers of the 2016 amendments had in mind transitional provisions or clauses to guide the administration of state affairs, including those relating to state organs, including the office of the president, so as not to create a vacuum. With regard to the office of the president, Section 7(1) of the Act provides that the president shall continue to serve as president for the unexpired term of that office as specified by the Constitution in accordance with the Constitution. The question that arises from the above provision is, which Constitution does Section 7(1) refer to? The answer to this question is to be found in Section 2(1) of the Act, which in the earlier provides as follows. Constitution means the Constitution of Zambia 1991, in force immediately before the effective date. Effective date means the date of commencement of this Act and the Constitution as amended as provided in Section 4. From the above provisions, it is our considered view that quite clearly the first respondent's first term, which ran from 2015 to 2016 was saved by the transitional clauses, and in particular sections 2 and 7 of the Act, and continued with the repealed Article 35 of the Constitution. In terms of the term limits, the repealed Article 35 was therefore applicable to his first term. Article 106 of the Constitution did not apply in retrospect, contrary to the holding in the Legal Resources Foundation case. The decision, therefore, is per incuriam. We accordingly depart and vacate that decision and previous decisions which made similar findings contrary to the well-settled principles of the law, that the law does not operate in retrospect unless it expressly states so. There is no provision that provides for the retrospective application of Article 106 of the Constitution. As we clearly stated in the case of Lucas Hamatoe and others versus Zambia Postal Services Corporation, when we said, it is trite that the law does not operate retrospectively unless there is a specific provision providing for the retrospective effect of the law. And there is abundant case law on this principle in this jurisdiction. Further, we said in the case of Lucky Mutambo versus Attorney General that if this court was to grant the petitioner's wish, it would be retrospectively applying the provisions of the Constitution as amended unreasonably without any lawful purposes, without any lawful basis, and ignoring the provisions of the Act number 1 of 2016. It is our conclusion that prayers A and B must fail. They are accordingly dismissed. Having considered the provisions of Section 2 and 7 of Act number 1 and the repealed Article 35 of the Constitution, we take the view that the decisions in Daniel Pule, Pampika Palace, and Legal Resources Foundation were arrived at per incuriam, as Sections 2 and 7 are clear that the first term that ran from 25th January 2015 to 13th September 2016 was captured by the repealed Article 35 of the Constitution. For this reason, we further dismiss the first respondent's argument that the question of his eligibility to contest the 2021 elections and therefore this petition is res judicata. As earlier guided, a matter cannot be res judicata where a previous case was decided per incuriam. On the same footing, this petition cannot be said to be res judicata. For this reason, reliefs 4, 5, 6, 7, 8, and 9 have merit and are hereby granted. Before we leave this matter, we feel compelled in the public interest and as a guardian of the Constitution to put to rest a fundamental misconception about Article 106 of the Constitution. The matter before us was premised on the assumption that Article 106, Sub-Article 6 of the Constitution qualifies Article 106, Sub-Article 3, thereby enabling a person who takes up a prematurely vacated presidential term of office to vie for and serve a further 2 terms in office. This assumption that there is, in inverted commas, a 3rd term in Article 106, Sub-Article 6, has been the source of much public tension and uncertainty, hence the need for our intervention. In a bid to address the issue, the third respondent submitted extensively on the principle of mandatory alternation as the source of Article 106, Sub-Article 3 of the Constitution and its antecedent, the repealed Article 35 of the Constitution. He contended that there was a contradiction between Article 106.3 and Article 106.6 of the Constitution, which ought to be reconciled or harmonized by ranking the two provisions so that sub-article 3 is superior to sub-article 6. That this would ensure that the latter did not essentially destroy the former. Although the point was not responded to nor argued by the other parties to the case, we are of the considered view that its import ought to be ventilated in the interest of protecting the integrity of the Constitution. We wish to elaborate on mandatory alternation, firstly by cross-referencing to the submissions recited in paragraph 4.12 and 413 at page J24. And secondly, by drawing support from Hector Fix Fierro and Pedro Salazar Ugarte, whose work entitled Presidentialism reads at pages 629 to 630 of the Oxford Handbook of Comparative Constitutional Law as follows. The source of legitimacy of presidential power lies then in a set of rules, in brackets laws and institutions, that broadly correspond to the forms of modern democracy. More precisely, these rules provide for the necessary, regular and periodic replacement of the head of the executive power through popular vote. The renewal of the presidency is provided for in the Constitution and carried out at fixed intervals. Besides exceptional circumstances such as impeachment, death, resignation, and the like, the president stays in office for a fixed period, generally between 4 and 6 years, with or without the possibility of being elected for more than one term. The third respondent contended that Article 106, sub-article 3, is the hallmark of mandatory alternation. With that in mind, we perused the first and final draft reports of the Technical Committee on Drafting the Zambian Constitution, TCDZC. The first draft report contains draft Article 103, which provides as follows. 1. The term of office for a president shall be 5 years. 2. Subject to clauses 3 and 4, a president shall hold office for one term, commencing from the date the president-elect is sworn into office, and ending on the date the election results are announced, and shall be eligible to be elected as president for a second term. 3. Notwithstanding anything in this Constitution or any other law, a person who has twice been elected as president shall not be eligible for election as president. 4. The president may in writing, signed personally and addressed to the Speaker of the National Assembly, resign from office. In the words of the TCDZC, the rationale for the article was that it was important to limit the number of terms to be served by a president in line with the current Constitution, to avoid the tendency of an individual wanting to be in office in perpetuity. The committee therefore resolved to retain the provision in the current Constitution. The final report of the TCDZC shows at pages 285 and 286 that draft Article 103 was unanimously adopted by the people's representatives at a district consultative forum, the provincial conventions, the sector group convention, and the national convention without any change. However, the TCDZC amended the provision to include the issue of a vacancy in office and the deeming, in inverted commas, of an inherited term. The recommended TCDZC final draft provision in draft Article 104 as a reason for amending the draft article the TCDZC said that it amended the article by providing for circumstances where the vice president or a new president serves an unexpired term for a president who does not complete his or her term of office. The committee observed that it was important to make a provision as to whether or not the inherited term should be counted. Draft Article 104 is replicated word for word in Article 106 of the Constitution. For convenience, we have set out Article 106 in its entirety. It reads, 106.1. The term of office for a president is 5 years, which shall run concurrently with the term of Parliament, except that the term of office of president shall expire when the president-elect assumes office in accordance with Article 105. A president shall hold office from the date the president-elect is sworn into office and ending on the date the next president-elect is sworn into office. 3. A person who has twice held office as president is not eligible for election as president. 4. The office of president becomes vacant if the president A dies, B resigns by notice in writing to the Speaker of the National Assembly, or C otherwise ceases to hold office under Article 81, 107 or 108. 5. When a vacancy occurs in the office of the president, except under Article 81, A, the vice president shall immediately assume the office of president, or B, if the vice president is unable for a reason to assume the office of president, the speaker shall perform the executive functions except the power to 1. Make an appointment, 2. Dissolve the National Assembly, and a presidential election shall be held within 60 days after the occurrence of the vacancy. 6. If the Vice President assumes the office of President in accordance with Clause 5A, or a person is elected to the office of President as a result of an election held in accordance with Clause 5B, the Vice President or the President-elect shall serve for an expired term of office and be deemed for the purpose of Clause 3A to have served a full term as President if at the date on which the President assumed the office at least 3 years remain before the date of the next general election, or B, not to have served a term of office as President if at the date on which the President assumed office less than 3 years remain before the date of the next general election. Article 1063 of the Constitution, when read with Article 106, Article 6 of the Constitution, provides that a person may or may not be deemed to have served a full inherited term. In common parlance, deeming relates to viewing or perceiving something in a contrived way. More formally, Black's Law Dictionary, 9th edition, gives as a main definition of the verb deem to treat something as if 1, it were really something else, and 2, it had qualities that it does not have. Hence, deeming allows an inherited term to count or not, depending on the length of time served. In our considered view, a contradiction between the two sub-clauses arises if the objective of the deeming is to enable the person who served an inherited term to contest more than one future presidential election, as it would create an exception. We have considered the issue on the basis of well-settled principle that constitutional provisions should be interpreted in a manner that harmonizes them. An exception to the clear prohibition in Article 106, Subarticle 3, would have to be explicit and cannot be imputed from the language of deeming, especially in the face of the people's expressed commitment to a maximum of 2 terms. Hence, the deeming can only be consequential as opposed to empowering or permissive. We are of the firm view that the words "be deemed for the purpose" are intended to settle post-presidential questions about the legal status and entitlements of a former president, as opposed to providing for a person's eligibility to return to the presidency beyond the mandated 2 terms. On a holistic reading of Articles 1, 5, 8, 9, 118, and 267 of the Constitution, with Article 106 of the Constitution, we find that Article 106, Sub-Article 6 of the Constitution, does not create a 3rd term. Final orders. Our combined interpretation, therefore, of Sections 2 and 7 of the Act and the repealed Article 35 of the Constitution is that the first respondent's term of office, that ran from 25th January 2015 to 13th September 2016, constituted a term of office. The first respondent's term, which ran from 13th September 2016 to August 2021, constituted his 2nd term. The first respondent, Mr. Edgar Chagwarum, has therefore been twice elected and has twice held office. Article 106(3) of the Constitution makes the first respondent ineligible to participate in any future elections as a presidential candidate. Our finding in paragraph 833 above does not affect the first respondent's participation in the August 2021 presidential elections. For this reason, we do not find merit in relief 1, 2, and 3, and they are considered and they are accordingly dismissed. Reliefs 4, 5, 6, 8, 7, and 9 have merit and are hereby granted. In light of the significant constitutional issues that have been raised in this matter, we order the parties to bear their own costs.
Much obliged. Very much obliged.
This brings us to the end of today's sitting. We enjoin all those present in court to maintain silence until the court has risen.
Yes, 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 yes.
Features from the Supreme Court and also the Supreme Court sitting to decide in a matter of former president, which I believe was judgment being over 2 hours. Of course, it's practically rapid following this case. This is
ruling that the 2 terms that the former president served do constitute a term of office. I'm not alone today. I'm with my colleague Kelvin Chifokolo, looking at what has been presented today. This is a case, a matter which we have been following up, which has been of public interest.
Public interest, and like the argument have been that this was the 4th time that the issue of the eligibility of the former president was being presented before the court. We have been following the Bumpy Kapalasa, the legal foundation, and not forgetting the Danny Pule, and now Mijelo Chizombe, who is a youth activist. Indeed, judgment has been given, a preamble or background has been given, so that people out there or Zambians can appreciate where we are, what has necessitated to bring us where we are, and also moving forward. I think at the end of the day, if you are to ask me, my first impression of the judgment is that Zambia has won and not an individual. Why do I say so? It's because it is the issue that borders on the Constitution. And remember, the Constitution is a supreme document of the land. And so if we are to follow the Constitution, we as a nation, Zambia, it means that we are winning and we are making progress. That has been the argument. And if you check the 3 cases that were before the court involving the eligibility, they were basing on Article 106. But with Mijelo Chizombe, there were fresh grounds or new grounds, and Judge Shirini also talked about the new grounds in bringing the 1991 Constitution, which had was not clear on what constituted a term, and so that was repealed. But now he was seeking, because the 2015 presidential by-election was held under 1991 Constitution. So we have been discussing a man who has been elected twice using 2 different constitutions, the 1991 and the 2016 amended Constitution.
Well, definitely, we did see a number of issues coming up there, and one of them is that the fact that the law is non-retrogressive, meaning the enactment of a new law does not affect what happened before that particular law is enacted. And just like you have mentioned, the 2015 elections were held based on the 1991 Constitution as amended in 1996, and so that is a basis by which this judgment has been made to a full term of office between 2015 and 2016, and the one which is between 2016 and 2021. A number of other issues, like the issue of res judicata, where the court, in this case, the court was looking to actually overturn its judgment and not review the judgment which was made previously in the 3 cases which you highlighted: the Danpule case, Bumpy Kapalasa case, and the Legal Resources Foundation case. So that being a factor, really it's really important for maybe us as citizens, besides the lawyers, to understand the Constitution.
Yes, because when you read the preamble of the Constitution, it talks about citizens having knowledge and understanding of the Constitution. So it is not a document for the lawyers. Of course, we know they are trained, and that is their profession, that is their work. But as citizens, as members of the public, there is that need of us understanding the Constitution. Kafang, I'll give examples of people that have taken matters to court before, and they didn't even seek for, legal representation. I can talk of Sean Enoch Tembo, I can talk of, Peter Sinkamba, just to mention a few. These are people that have taken matters to court before, and they represented themselves. They didn't have any lawyer representing them. So yes, you are right. We just have to read and understand, having basic knowledge and understanding of the Constitution. We can talk about the person that sued in Mijelo Chizombe. The little knowledge that we know about the young man is that is a medical practitioner and not a lawyer. So which for me indicates or proves that as a citizen you've got the right. Once you read and understand the law, you can argue or take the matters to court. Like I've said, for me it is not Mijelo Chizombe who has won, but it is Zambia at large, because it is a precedent. Like I've said, it was very, very clear that we were discussing a man who was elected twice using two different constitutions or amendments, and it was so worrying that our learned councils were just relying on me, Article 106 and the 2016 amended constitution. And so that is why this matter was adopted in court, because the man, or Mijelo Chizombe, raised new grounds different to the grounds that Danny Pule, Bampi Kapalasa, as well as the Legal Resource Foundation raised. And so here we are. The call is that let us read, have basic knowledge and understanding of the Constitution, because this is our document.
Sure, as we go on dissecting the issue, I'll invite our court reporter Namangola to also join us on the screen. But one of the aspects that has also been brought out in this particular case as the judgment was being delivered is the fact that what is the status of the election in 2021, because there was speculation that actually this judgment would actually render those elections void. But the fight on that matter and talking about the issues to do with the Constitutional Court making itself pronounced in the eligibility of the former president then in 2021, and of course the court, because of that particular reason, the court cannot overturn that particular decision which was made by the court, and so it means he was eligible in 2021 but not eligible for future elections. Namangolo, you've been following this case. Your reflections after this judgment?
Well, it has been long time coming, but the Constitutional Court has finally ruled on this matter. They've stated that the former president, Edgar Lungu, was actually eligible to contest the 2021 elections, and also that inherited term, so he referred to it because he was given that term in 2015 up to 2016. So they said that inherited term also constitutes a full term. According to the court, that was a full term. So he had served office twice and he was elected twice to the office of the president, so he was eligible to stand in 2021. That's what the Constitutional Court has ruled, and because the first term that he served from 2015 to 2016 is considered a term, therefore the court has ruled that he is no longer eligible for any other future elections.
Well, definitely. Bring in Kelvin. Yesterday we saw the opposition talking about issues to do with this particular case and the precedents being set in that another petitioner may come up again to challenge this particular case. Maybe what would be your review concerning that?
Well, people have got the rights, and already there are indications. Kafwanga Namangolwa, I think if we were to be good students of history, this is a matter that has been before court and people were arguing. But I'll tell you that when the date was set, the 10th of December, and when we entered December, I think I saw a shift in people that were saying ECL was eligible. They were more like shifting the grounds. If you check statements that have been issued, it's like they knew or they saw it coming. and that is why they were changing the goalpost, bringing in the issue of that if the ECL is to be declared, if the court is to pass judgment that he wasn't eligible to stand, then we are likely to go for presidential election or by-elections, because the incumbent was competing with somebody who was not eligible. But here we are. Namangol has given us, the grounds. The judge in the judgment, it says he was eligible. So the elections of HH is secured, if you are to use that term. So, but of course, indications are there. People have indicated that they are going to, to petition or to file new grounds. That is the beauty about democracy. Did it come?
The people have to. Maybe your review on this one. Any petitioner can now again bring this matter before the courts because of the precedents that has been set by this particular one.
Well, power belongs to the people, like the court has said. Power belongs to the people, so it's the people that decide. But the court has a stance on this matter. They've said once you hold office twice, you cannot hold another term of office. So if you are elected to the office of the president twice, that's it. You cannot hold another term for it.
According to the constitution, as at when the former president was elected into office, that is 2015.
When he was elected into office in 2016, they were using the other constitution for 1991. But after the repeal, now the constitution stands that you cannot hold the office of the president twice.
Well, Namangola, you've been following a lot of these cases here at courts, and today is practically the first time that we've actually seen a live broadcast from inside the courts where the media has been.
I have to agree that's a very intelligent reasoning. They've said we are the ones that said he was eligible. We interpreted the constitution at the time that said that he was eligible in 2021. So you cannot say that his participation was unconstitutional, because we are the ones that interpret the constitution. We are the ones that breathe life into it, and we said that he was eligible. So his participation could not have been illegal if the court had legalized it. You understand? So I think that was very important, and so essentially meaning that even though they have declared that he is in fact barred by the current constitution from participating in future presidential elections, the 2021 election remains unaffected. So I think that the court has done a great service to the nation by setting aside the Legal Resource Foundation case and all other previous judgments on this issue. That is very important to know. Danny Bruno, Bandita Palasa, Legal Resource Foundation, all those judgments have been vacated. And they've done so because the Legal Resource Foundation judgment, in its reasoning whereby it allowed an amendment to a constitution to affect a sitting president, is a dangerous precedent to this country. It could mean that the current president will go to parliament and to the people, have a constitution amended, for example, on the duration of the term, and say a term will no longer be 5 years, to be 10 years, and then have that amendment applied to the term that he is currently running. You essentially had room to create a life president by constantly amending the constitution, and then that constitution applying retrospectively to the term that he is serving. That is as dangerous as it gets, and the public must understand this. That is what of this country.
So what's your view on the concept proposal to put precedence of Article 106 and Article 3? 106 and Article 6.
That's exactly saying that the danger that was perceived is that if those sections are not read in conjunction with each other, it then means that the current amendment to a constitution can apply to the incumbent president, which means that if, for example, HH wanted to increase the length of the of a presidential term, he could increase it, and that amendment could apply to him in his current term. You see, that doesn't put a limit on power. It means that somebody can remain president for life. So the provisions must be read in conjunction with each other. The intention is not for them to permit an incumbent during whose term the Constitution is amended, for that amendment to apply to him. The law should never apply retrospectively. If the incumbent changes the Constitution today,
number one, the court is trying to compare the jurisdiction of the South African court, of the